Good afternoon. We have two cases scheduled for oral argument this afternoon. Our first case is F&F Fiduciary Services, LLC et al. Versus Alicia Solomon as property appraiser. Counsel ready to proceed. Counsel, we have allocated 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Save 4 minutes for rebuttal, please.
So noted.
Yep.
You may continue, counsel.
I won't have to shout to this audience, that's for sure. May it please the court, my name is Chris Altenburn. Along with my partner, Eleanor Sills, I'm here today representing the three appellants, who I will refer to as Butler. Butler is challenging a judgment approving ad valorem property tax assessments for 2020 and 2021 concerning about 25 parcels in a very large shopping district. This appeal is challenging the PA's failure to prove that it was entitled to a presumption of correctness. Since 2009, under Section 194.301, it has been the obligation of the property appraiser at the beginning of one of these challenges to demonstrate that it has complied with considered the 8 factors in 193.011, and that it has also complied with professionally accepted appraisal practices. If the PA fails to prove this front-end step in one of these cases, and there appears to be some concerns about professional appraisals, the trial court simply needs to send the case back to the property appraiser for them to reassess it properly under that rule. In this case, that did not happen. Now, the professionally accepted appraisal practices that the PA is required to comply with are not expressly stated in the statute, and they clearly are not in the 2002 DOR guidelines that have now been disavowed. The department has repeatedly told property appraisers that they should look at 58 pages in the Uniform Standards of Property Appraisal Practices for the standards that they need to use to comply in a case like this. They did it in this case in page 576. But here, the two appraisers who performed the appraisals admitted that, or claimed that the USPAP did not apply to them. They didn't use it at all. The attorneys at trial told the trial court that the USPAP had no application to the Alachua County Property Appraiser's office. Mr. Kao, who did the majority of the assessments here, admitted that he barely knew anything about it. He'd never been instructed on it. And it's not like the department, the appraiser came forth and said, the Department of Revenue is all wrong, that there's another set of appraisal practices out there that are professionally accepted, and we implemented those. They simply did not come forward in this case with evidence that they complied with any recognized set of professionally accepted appraisal practices. And that impacts all 4 issues that I want to discuss with you. The first issue concerns their use of so-called SUT data. Before trial, the trial court erred by denying a motion in limine and allowing the PA's witnesses to testify about the process of using confidential sales and use tax information that the PA had obtained from the department. Because that data was confidential, it could not be disclosed even to the judge, let alone to Butler.
Do you agree, counsel, that the data is confidential by statute?
Yes, I agree that they're confidential by statute. But the problem here is that the PA attained these apparently from 102 taxpayers that were paying sales tax on commercial leases without their knowledge and consent, but more importantly was using them for the process of setting just value for all of the property.
Could not your client have gotten it with a court order, gotten this data with a court order, with the judge putting some kind of protections to make sure it's still confidential?
Theoretically, under pre-2009, when it was the burden of proof of the property owner to prove things under the every reasonable hypothesis standard. There's case law discussing them getting it. But the problem here is that we knew that they had to comply with the statute, and that the only way they could comply with the statute was to present testimony based on things that were admissible evidence. And instead, they were using top secret, no, that's an exaggeration. They were using undisclosed documents that were not shown to the judge, that are not in the record, and it was basically a trust but don't verify approach to appraisal. And there's no suggestion that any set of rules concerning professional standards for appraisal practices would allow someone to use evidence that cannot be disclosed to the property owner in the interviews before this process begins or during the VAB
Counsel, your
hearings
motion
or
in
afterwards.
limine filed in the trial court was a reference to this data, is that correct?
I'm sorry, I didn't.
Your motion in limine, which was filed in the trial court, was in reference to this data.
This
Is that
data,
correct?
and keeping it out of evidence not to obtain it. It wasn't that we were trying to seek it, it was we wanted to keep it out of
But
evidence.
that begs the question, why didn't you move to compel the production of the sales and use data pre-trial?
Well, we could have, but we didn't need it in our case. If they were going to use it in their case, they needed to give it to us, but it wasn't something that we needed to prove up our case. They were going to need it in the front
But shouldn't that have
section
been a
of
part
this.
of the discovery process?
Well, in the discovery process, we asked for it and they declined to give it to us.
Well, then, shouldn't you have filed a motion to compel?
Well, I could have, but we did not need it. We could not show we needed it for our case. We wanted to see it because we thought they were going to use it. And when they declined to give it to us, we took the position that no testimony related to it should come in. I mean, if they can show that professionally, accepted appraisal practices would allow the use of non-disclosed evidence, especially for a government assessment like this, that's fine. But there's no suggestion that that exists. So based on that, we did move in limine, and they argued that they could do this under section 195.027 subpart 3. It was their argument at trial. And they used the cases when it was the property owner's burden to overcome the every reasonable hypothesis. Those cases, I would submit, don't have anything to do with whether this is an appropriate appraisal process for the appraiser to use and to demonstrate to the court. Now, oddly, the PA has abandoned that argument on appeal and is explaining that it lawfully got this data under other statutes from the DOR. Now, the DOR doesn't completely agree with that, but the problem is it's not whether they got it lawfully. The question is, can they use this information? And they presented nothing to show that there was a presumption of correctness arising from the fact that this is something that appraisers could do under the standards that are applicable. So they talked the trial judge into this, it's their error, and they cannot prove it's harmless. Now, the second issue is whether or not the 70-30 formula is a problem here. Now, it also used the SUT data, but this was applicable for all assessments in 2021 because in January 21, the pandemic was still a thing. Now, the property appraiser knew it was, and so the property appraiser decided that it would create this formula to determine whether there was impact. Now, this formula is looking at sales tax from 2019, 2018, I believe, at the two prior years. And there's no evidence that anyone other than Alachua County used this. No other property appraiser apparently used this. The department didn't recommend it. This is truly a novel formula, and it's based on information that we're not allowed to see because of the fact that it's confidential. So again, I mean, I can't actually articulate a reason why that sales document evidence would be something that would explain why the cost or the hypothetical sale in January of 2021 that is used for assessment purposes.
How did the application of the 70-30 formula impact the assessments at issue in this case?
Every single one of them, they went and looked at that and said, not a single thing here, not any of these parcels should be reduced 1 penny because of impact of the pandemic. So it in fact affected all of them for the 1 year. It has nothing to do with 2020. But the notion that all of these things, that there was nothing that the pandemic at that time did to reduce it even $1. Now, admittedly, the pandemic may have bounced back a year later, but for that year, they did not use this as a professionally accepted practice to prove that they shouldn't discount the values at least a bit during that year. And we submit for the same reasons that is an error. The third issue is the issue of what I'll call location. And this deals with the PA's misunderstanding of the location, both in the context, I believe, of whether there's intangible property involved in this, and also as to the question of, maybe they just misunderstand what location should mean for purposes of a 193.011. The problem here is that they are measuring value that exists only for the current owner due to its successful management of this development over a 2-generation time. And so you need to understand that the property taxes are measured by the unencumbered fee simple. Under Schultz, which is a Florida Supreme Court case from 1973, the property appraiser doesn't have to take into consideration mortgages against the property or leases on the property. Now, to be clear, about 95% of the time, that's just an absolutely great rule for the property appraiser, because they come in and say, well, you have a lease you got on this property from somebody 10 years ago, and you could get a lot more now, and so we're going to assess the property higher than the income you're making on this lease, because the hypothetical owner, for property purposes, gets this with the opportunity to have a new lease. That work, and most of the case law is that. But that doesn't work for Butler and for this case. In this case, Mr. Briner and Mr. Kale emphasized that location, location, location were the big factors in determining just value. But the problem with their methodology was that they were relying on the leases that Butler, as the owner of the whole thing, could negotiate with various people, including big box stores. And they were assuming that the hypothetical buyer who buys one parcel is going to be able to do exactly the same thing. But the problem is that this is only dealing with one portion of an overall neighborhood. It's going to have no market power. Now, if you consider just the undisputed facts for 2020, the seed that grew Butler Plaza was Clark Butler's Curb Market, 1939. He bought more and more acreage along Archer Road, and eventually Deborah Butler took this over. She was well educated in the finances of commercial development. She created this plan for a series of planned use developments, and she grew this thing from a small store operation to 2 million square feet of retail. There's 150 stores, including big boxes like Lowe's, Walmart's, Best Buy, Sam's Club in here. It has 35 restaurants. There are traffic lights. There's a fire rescue station inside this district. This is not a mall. This is a district that they built. The PA's expert claimed that it was a conglomerate model, and that means that Butler could track the big brands, and the big brands could bring in the customers, and that was what was bringing in the customers. He's probably right. But the issue here is not whether Butler had a brand like the Nike swoosh that was bringing in customers. The issue is that the PA was claiming that the unencumbered just value of Butler's parcels should be higher because Butler could obtain higher rentals from the big names and from the smaller names because it had all of this. And to be clear, it's not just the witnesses testifying to that. At page 1218 of the transcript, Ms. McLean explains to the judge. And so I was trying to show, he just testified that not only are we looking at the size of the individual parcel, but the vast size of the plaintiff's property. So what they're doing is not making an assessment based on unencumbered fee simple of one parcel. They're looking at the market power built by skillful management that can negotiate other leases. Now this hypothetical buyer, what's he getting? He's getting one lot. It's a great place for the Butlers, but he is now surrounded by competition. The neighborhood for him is not a friendly neighborhood. And so here he is trying to renegotiate a lease, this hypothetical person, with people that the Butlers are in a far better shape to negotiate with. No reasonable hypothetical buyer of these properties is going to pay assuming that they can get the same leases that Butler can, because they don't have this ownership that was developed that is, in fact, recognized under law as an intangible value of a skillful manner. Now, to be clear, if the government had set up this as a big zoning area and then had invited everybody to come into the district, then it wouldn't be the Butlers. Or if you could get higher leases because, I don't know, Pikes Peak's in the background, that wouldn't be the Butlers either. But what we have here that gets higher leases is what was developed by the private property owner owning the vast size of this. And the trial court did not understand that, and there's no suggestion that Florida law, much less appraisal practices, would allow you to develop this, to measure the parcel by this because of the vast size of the other. If you look at Interlochen Lakes Estate, you're supposed to measure parcel by parcel, and you don't consider what the private owner's circumstances may be.
Counsel, excuse me. You are into your rebuttal time. But before you sit down, regarding the cost basis
Yes.
determining the valuation of property, what evidence and authority supports your argument that the cost approach to valuation included non-taxable, intangible property?
Well, if you have intangible property, you cannot tax it as constitutionally, period, under any form of assessment, no matter what you use. Keep in mind that income, cost, and market are three appraisal methods that can be used as tools to get to a just assessment. But despite the name of the property appraiser being an appraiser, they're doing assessments. And in this situation, I haven't really gotten to the cost part with Mr. Kao, and since I'm running out of time, I'm just going to point out that this man knew nothing about the USPAP. He was running these on a CAMA program, a computer program that they admit did not have in it the ability to deal with external or functional depreciation processes. Nothing was depreciated a penny for these reasons. And the poster child of this was the Regal Theater, which by this point in time was competing with a theater a mile and a half away that was a new high-tech theater that was far more functional. And moreover, Ms. Butler testified that it had taken away half of the people visiting that theater. And yet there were no adjustments at all for functional and external there. So I'll save my 2 minutes.
Thank you, counsel. We will extend your rebuttal time by an additional 2 minutes.
Thank you very much.
And we'll extend counsel for the appellee's time by an additional 2 minutes.
Thank you. Good afternoon. May it please the court. I'm Jennifer McLean. I represent the property appraiser for Alachua County, Ms. Aisha Solomon. I'm actually out of Sarasota. My law firm is Denton McLean. My firm has been representing property appraisers throughout the state for 50 plus years. And it's an honor to be here with you today. I have a prepared comments, but I'd like to just touch base on a few things that the court just asked counsel. Primarily the cost approach. The cost approach does not capture intangibles, and so that is undisputed. We heard testimony from all 6 experts at trial that the cost approach done correctly does not capture any intangible value. So the intangible issue only really applies to the parcels that were assessed using the income approach. Regarding USPAP, Mr. Kao is here. He's here today. He has worked for Miami-Dade County. He has worked for Alachua County. He's a 20-plus appraiser. He absolutely knows what USPAP is. USPAP had very, very little to do at trial. In a 6-day trial, USPAP came up very little, and the reason it came up is because that the appellants were arguing that we were not using the correct highest and best use. And we were not using the highest and best use standard that USPAP puts forward. And our response, including mine, counsel's correct, I advise my clients that they have to look at 193011, and that gives a little bit different of a version of the highest and best use. And so it was only in that limited area where USPAP came up, and so the idea that Mr. Kao does not know USPAP is absurd. We absolutely believe that USPAP provides professionally accepted appraisal practices. We do not believe that we are bound by USPAP under Section 475. Why? Because 475 applies to licensed, registered appraisers. Our appraisers do not have to be. I do have an AGO opinion that states clearly we are not bound by USPAP. Those were the two issues I wanted to just comment on briefly regarding counsel's argument. As stated, the taxpayer challenged the 2020 and 2021 tax assessments of the subject parcels located in Gainesville, Florida. Location is absolutely key to this case. Location is one of the factors that the property appraisers are mandated to consider. And that's, again, 193-0113 speaks to location. Not sure if you all are familiar with Gainesville, but the location of the subject parcels are right off of I-75 and Archer Road. That's exit 384. It is the most trafficked exit. It is, the subject parcels are very close to the University of Florida. They're a mile away from Shands Teaching Hospital. It is our position, it is the property appraiser's position that this is superior. They refer to this area as the Archer Road corridor. They refer to both sides of Archer Road as the Archer Road corridor. The appellant's parcels are only on the north side of Archer Road. However, the property appraisers assess both the north side and the south side equally, the same. So it's not a Butler side, it's Archer Road corridor. And it absolutely is the best location, and it absolutely should be considered.
Counsel, how does the presumption work in the ad valorem tax assessment process under Section 194.301?
I'm sorry, how does the presumption work?
Yes.
Yeah, so absolutely, there's no disagreement on the presumption and the statutory change in 2009.
Would you explain it?
It did shift the burden. The burden is on the property appraiser to provide competent substantial evidence that we considered the 8 factors of 193-011, and also that we utilize professionally accepted appraisal practices. So the trial court found that we did meet that burden.
Okay. But what happens if the property appraiser fails to meet her burden for the application of the presumption of correctness under Section 194.301?
If we fail to meet the
yes.
burden, well, I think the case no longer goes through. I think the appellant has the opportunity at halfway mark to ask the court, have you found that they utilize the professionally accepted appraisal practices and consider the 8 factors? So I think we're dead in the water if we do not consider the 8 factors and if we do not use professionally accepted appraisal practices. So then the statutory change that we are all in agreement, the trial court correctly ruled on the statutory change, included the correct legal presumption. The Department of Revenue, who is our oversight, stated that the trial court and the ruling is correct regarding the presumption. It then does shift the burden, and that was the change. The burden shifts now to to the taxpayer to then prove that just value has not been reached, or that second part of that statute is that arbitrary appraisal practices had been used. So the burden does shift. I'd like to touch on set data. This is not secret data. This is sales and use tax data. It is provided directly from the Department of Revenue. Again, the Department of Revenue is our oversight. They provide databases to us to assist us in preparing the tax roll.
Counsel, is the property appraiser still using sales and use tax data in assessing properties, or has the issue become moot with the repeal of Section 212.031?
Well, I don't think it's moot. Certainly, there are hotels are still going to have to provide set data, so it's not completely moot. I think for some parcels it's going to be moot. But again, the repeal of that had nothing to do with ad valorem taxation or the ability to use it. I think other reasons, but no. So it's not going to be moot. There's still going to be some parcels that are going to be required to submit set data. Statutes are clear. 195.084, 213.053, Rule 12D, 1.006. These three statutes provide for the evidence, the exchange of information, the exchange specifically of sales and use tax data from the department to the property appraiser. So the idea that we can't rely on something the department is giving us to assist us, it makes no sense.
Well, did the property appraiser have options besides relying on sales and use tax information in appraising the parcels at issue?
Well, and that's a great question, because sometimes taxpayers provide their actual income and expenses, but the appellant did not provide that. So we did not have actual data regarding the subject properties. So the only other option, not only option, so we rely on the set data. There are also other things that the property appraiser testified and the court included in their ruling that the property appraiser considered. So what is widely used are third-party publishing sources, specifically CoStar. CoStar was used. Appellant's expert witness relied on CoStar as well. So the property appraiser looks at things like CoStar. They look at overall market knowledge and data. The property appraiser looks at income that is presented at the value adjustment board stage. They look at income that is provided in those expense and income questionnaires that are sent out every year. So the reliance wasn't just on set data from the department. There were many things that the property appraiser relied on, but because the appellant didn't provide their actuals, we could not look at their actuals. So really what they're trying to do is tie our hands. We're not going to give you our actual information to assess the subject property, and you can't use set data because we're not going to have access to that. They didn't want to look at the set data. It hurt their case. They didn't want it included. They want to tie our hands and allow us not to defend our assessment. Absolutely, you asked earlier, Your Honor, could the taxpayer have filed a motion to compel? Yes, that's what the Aetna case tells. I mean, it gives this clear direction. It's, I think I said it in my brief, it's civil procedure. So yes, we objected. We objected in discovery to the set data, but the property appraiser isn't permitted to disclose it. It's statutory. We're not allowed to. But what the Aetna case showed us is that if the taxpayer motions the court properly under civil rules of procedure, that the court then makes that weighs the difference, the benefit, versus then the ability, is it necessary information? But we never got to that place where the court could even look at that and balance those interests. The court in Aetna did rule that it was necessary information, and it was other taxpayers' information. It's 100% on point. And so that was the one option. They could have appropriately motioned the court. The second option, they could have deposed the Department of Revenue. Party to this action, they're formulating this database. There was no effort to understand this data at all. And I think the third option that they could have done differently and should have is present evidence to the contrary. Like that's what Daubert talks about that. You know, they refer wanting to be able to cross-examine, but once we got to our burden was met, they then had the burden to come in and show it wasn't just value. They had the option to enter evidence to show that the market rents we used weren't appropriate. That's what it's about, the market rents. And so not one of their 4 experts brought any evidence in to show that, the rents in our income model are too high.
Counsel, what is the 70-30 formula in this process?
Yeah, so the 70-30, it was not methodology. The 70-30 was a intentional weighing of income, and it was designed to, if there was a decrease because of COVID, it was designed to pick that up. But what happened, the market data showed that income for all of Gainesville retail, the income didn't decrease because of COVID. And then also there was evidence entered in that the actual appellant's income increased from 2019 to 2020. So because there wasn't any change in income, that 70-30 did nothing, had no impact on the assessment. But it was our attempt to pick up a decrease in income due to COVID. So we did attempt, but the market showed
But
otherwise.
did the property appraiser establish that the 70-30 formula was developed pursuant to professionally accepted appraisal practices?
Yes, I mean, yes, weighing evidence and historical data is absolutely acceptable. It's an acceptable appraisal practice. To look at data, USPAP, which is cited in my brief, absolutely states that the property appraiser should look at historical trends and weigh data. You have to look at the market, and with something like COVID, they had to look at the market to determine how the market was going to react and look for the data, and that's what they did, and it showed that there was no decrease in income or effect of COVID. By January 1 of that next year, that 2021 year, people were back in business. Certainly, the subject parcels, their own leasing officials testified that people were back in business by the summer. So by that following January 1, certainly Gainesville was not seeing the effects of COVID. Important to note that COVID only applies to the 2021 year. It has no bearing on the 2020 year. I'd like to touch base on the intangible argument. Very clear, very simple. The trial court said it eloquently. The property appraiser utilized market rents. They did not utilize the subject rents. None of the Butler Plaza rents, none of the parcel rents were used in determining our market rents. So it's impossible for our assessment to capture intangible value because we did use the market rents. And by the way, we used market rents directly across the street from the southern side of Archer. We used market rents from inside the corridor, the Archer Road corridor. That was the problem with their expert and why the court was not persuaded by their expert. Their expert came in and tried to establish market rents and looked at areas all over Alachua County. They looked at High Spring. Again, I'm not sure if you know Gainesville, but High Springs is a small town. Alachua City is a very small town. So that's what the trial court in the ruling stated that their expert didn't bring in market rents that were comparable or in that comparable location. Again, back to location, it's really important when you're using market rents to use a comparable location. So the idea that in any way the assessment captured intangible value, it's not accurate. We were assessing it based on across the street. What happened then when we got to trial and we looked, they finally bring in their actuals. So their experts had the ability to look at their actuals and bring those in. And when we looked at their actual income is so much higher than even what we were using.
Did COVID-19 have an effect on their market rent in 2021?
I'm sorry?
Did COVID-19 have an effect on the appellant's market rent in 2021?
Well, when we are assessing 2021, as of January 1, 2021, we're looking at the 2020 income. So that was the COVID year. And that is the income we looked at. And all of the market data showed that the Gainesville retail market did not decrease. And then their actual income that they brought in showed that their rental income did not decrease. So again, the property appraiser looks to the market. They look to the market for direction. And when we looked at the market, we did not see a decrease. Regarding the cost approach, there's three types of parcels that are on the cost approach. It's standalone restaurants or fast food restaurants, new construction, which is mostly vacant, and then there was Regal Cinema. We've heard a lot in the briefs about Regal Cinema. These parcels were assessed using the cost approach because the property appraiser did not have reliable income or sales data. They had no other option. In fact, it would have been irresponsible to ultimately assess those parcels using the income or the sales approach because we just didn't have the data. And if you think about it, the Regal Cinema, there's only a couple movie theaters in Alachua County, so there's not sales. And neither one of the movie theaters report their data. So we have no other option but to utilize the cost approach. Again, I think it's important, and I know council stated that there's three approaches. The cost approach is an accepted approach. We're mandated to consider it. Their expert ran a cost approach and presented it to the court, entered it into evidence. So certainly.
Regarding the cost approach.
Yes.
Were the three depreciation factors considered in assessing the properties using the cost approach?
Yes, so the cost approach is replacement cost new, less depreciation, plus land value. So the cost approach is developed within the CAMA system, which is the computer a mass appraisal system. But the CAMA system is what the property appraiser uses. So that on its own captures depreciation, physical depreciation, as probably you and I understand. The property appraiser testified that he also considered the other two types of depreciation by looking at the market. So that's the obsolescence. It's functional and economic. And if you look at economic obsolescence, the definition, and it's in the Darden v. Singh case, the definition of obsolescence is it cannot be overcome, and it's incurable. So when the property appraiser looked at the market and realized that things were back open, back running, COVID was temporary, there was little impact, the property appraiser did not see obsolescence in the market data. And that is exactly what the property appraiser is supposed to do. The Darden case talks about looking to the market for obsolescence. But you can't apply obsolescence if you don't have market data showing you that exists. And the Regal Cinema was back operating. It's older than the brand new one, but it's been updated, it's been renovated. So the idea that this building is somehow obsolete is inaccurate. I just have a minute just to make sure I'm not missing anything. So in conclusion, we had a 6-day trial. The trial court listened to extensive testimony, 6 experts as stated, and the trial court correctly found that there was competent substantial evidence that the property appraiser considered the 8 factors and used professionally accepted appraisal practices. do not see any area where the appellants are challenging or, or stating an error in law or coming up with, in any way, any evidence to show that we did not meet our presumption. Do you have any further questions?
Thank you, Counsel.
Thank you.
Let me address some issues on the cost issues first and then go to the others. When the question was asked about does cost exclude the things that are skilled management and the like, that is correct, that it does not do that because of the nature of that. But what I was trying to point out, she uses the phrase economic obsolescence, but the testimony was that it should include 3 forms of depreciation, functional and external. And that is not in CAMA. And Mr. Kao said he didn't decrease anything for these things. And the Regal Theater was the one where the building, because of its age, was markedly different than the one down the street. The number of people coming to it, the testimony was, had been cut in half because of the competition from the external side, and not a penny was reduced on that. So, and I would emphasize that while it's not supposed to consider other factors, the discussion about location, and the fact that they were doing this based on the vast size of this, that discussion was taking place during his testimony. Now, second, as to we didn't give sales tax. Well, we turned in our sales tax, but we turned it in for the entire district because that's the way they do the accounting. They were expecting us to recalculate everything parcel by parcel and parcel for them. The truth is, from the testimony, that practically no one does this for them. But more importantly, they testified. Mr. Kao got 18 assignments, I think it was. He did all 18 by cost. Mr. Briner got 8 assignments. He did them all by income. That was because they explained that they had policies set up so that certain types of things got done one way or the other. It was predetermined really before it ever got to these people which one they were going to use. So even if we turned in sales tax, Mr. Kao felt that because things were comparable with things owned by owner-operated businesses, he had to use the cost method. So the notion that these 2 men were separately weighing all this to decide that, that's not what the testimony shows. This was set up by policies ahead of the time. So even if we had done all this accounting, he was going to do all 18 of them by the cost method. Now, as to the fact that the materials that DOR has is not secret, well, you don't see them in the record. They're secret to the property owner. The property owner would have to justify an essential need to see this material. And by the way, the DOR says, well, at that point in time, we got to get 102 people in here because they have to consent to it before it can be made public. And so it's not as simple as filing a motion to compel anymore, because the department's explanation in their brief is that there are different statutes that cover this, and that they did not understand that. So we're using secret data, and they're asking a court to decide whether they reach just value by trusting them with the inability to verify anything about what they did under SUT data for all of the income appraisals for both years, and for the income approach that was used, that was a factor in everything that took place in 2021. So the last comment I will make, they were using market. They were using the other side of Archer Street. Well, the other side of Archer Street's a narrow strip if you look at it. And it gets impact because it's got Pikes Peak next to it. It's got our properties right across the street from it. But moreover, it's on the side of Archer that's going inbound. Everybody getting off the interstate that wants food, the side of the street they're on is that side, not our side. And if you look at what the properties that they were using to pump this up, they were restaurants on that side of Archer. So the notion that they were going and looking at things that were unconnected to Butler's Plaza is incorrect. They're just jumping across the street to use things that were impacted by the fact that they were next door to Butler. So with that, unless you have any additional questions, I thank you for your attention.
And thank you, counsel.